This is Phil Rizzuto from the Rizzuto Law Firm. Did you know there are 5 common mistakes people make when looking for a nursing home injury law firm to sue a facility that's abused or neglected a loved one? Well, we're going to go over those 5 common mistakes, and I'm going to tell you the single most important thing you need to know in order to retain an attorney and pursue an action against a nursing home. The first mistake people make is they feel they need to find an attorney who's conveniently located to them. And that's absolutely not true. Most attorneys who handle these cases cover a large radius, they cover multiple counties, and are able to take these cases regardless of where the nursing home is or where you reside, within reason. Attorney has to be admitted within the state that they're bringing the lawsuit for sure. But generally, law firms cover multiple counties and a very wide radius. The second mistake people make is they feel they don't have enough money to hire an attorney to consult with or pursue such an action. And that's not true. These cases are taken on a contingency fee basis, which means the law firm only gets paid if there is a recovery. And on top of that, the law recently changed in New York that gives the client an option not to have to reimburse the attorney or the law firm they retain for case disbursements in the event there is no recovery. It used to be, and a lot of people don't even know this, is that if you didn't succeed in your lawsuit, you had to pay the attorney back for case disbursements. Case disbursements include court filing fees, medical records, expert fees. In a nursing home case, these fees can run $10, $15, $25,000, $40,000, depending on how far the case goes and how much work is involved. So that was a big win for the clients who have that option of not having to reimburse the firm under any circumstance. The other mistake that people make, which I guess this is number 3, is they go to a law firm not knowing that the law firm they retain is not going to handle the case. And that's something you need to find out when you speak to the attorney or whoever it is you're speaking to when you're suing a nursing home, because these cases are very specific. And it is not uncommon for law firms to work with other attorneys to handle these cases. In some ways, that's not a bad thing, because they will use a firm that knows what they're doing. Okay, which brings us to the 4th common mistake people make, that they hire a law firm, and even if the firm is going to keep the case and not refer it out, that doesn't understand nursing home law at all. Right? There are laws specifically designed to protect the rights of residents. There are federal laws. There are New York laws and rules and regulations. There is the public health law, which is specifically designed to protect the residents' rights and prevent them from being victims of nursing home abuse and neglect. Many attorneys, and I've seen it, advertise that they handle nursing home cases, and they have absolutely no clue as to what these laws are. So you want to make sure that you hire an attorney that knows what these laws are. Going back to mistake number 3, you're almost better going to a firm that's not going to handle your case and it's going to refer it out to somebody that does, than to go to an attorney that's going to tell you they can handle the case and they have no clue what they're doing. Right? And we've taken over cases from attorneys and basically had to redo everything that they've done. And we've been boxed into a corner, but because we know what we're doing, we're able to get out of it and get the client's maximum recovery. So you want to make sure that whoever it is you hire knows the laws designed to protect residents' rights. And finally, the most important thing you need to know is you need to have the authority to retain the attorney. And I can't tell you how many calls we get from people that do not have the authority to proceed. We've had very few cases in the past 15 years where the victim of nursing home neglect has actually retained us. Most of these cases we're retained by family members. And if the resident is alive and they don't have a power of attorney, there's very little we can do unless a guardian is appointed. And that's if the resident is incompetent or not able to retain us. If the resident is competent and able to sign a retainer and knows the scope of what they're doing, that's a different story. But sometimes, and I would say in a lot of the cases, the resident has dementia and is incompetent, and there's no one who's able to retain us, and it's not worth pursuing a guardianship at that point. So in order for us to proceed, sometimes the individuals who contact us, we have to wait for the resident to pass away so that they have the authority to proceed. So if you don't have a power of attorney and the resident is alive and they're incompetent, then contact us anyway, and we'll figure out a way we can help you and develop a plan. And you need to retain any law firm that's capable of doing that. So if you found any of this information helpful, please hit like and subscribe to the YouTube channel. And if you have questions, you're always free to call me at 1-855-Rizzuto. I'll be glad to answer your questions, and if I can't or I can't help you, I'll certainly point you in the right direction to somebody who can. So thanks for listening, and have a great day.